Okay. Hi, everyone. Thank you for joining us. My name is Hardik Soni. I'm a physician. I own a bunch of med spas, and we're also kind of launched a couple of pretty amazing projects, kind of the most notable being Aesthetic Nexus. The entire premise of the Nexus is to really create kind of a global platform which serves as kind of, a collection of resources that you need to really kind of grow your practices, build them, scale them, and ultimately maybe even exit if that's what your long-term goal is. I know when I started, about 15, 16 years ago, I didn't know what I was doing. Did everything wrong. There were no kind of guidebooks. I don't know if Sarah was around in 2008, but I didn't know any of this stuff, and there was nowhere to find any of these resources, including regulations and kind of structures and kind of a pathway to really kind of build and scale your practice. And I came dangerously close to going bankrupt first couple of years, just real quick, losing something like $20,000 a month every month for the first 5 years. You guys can do the math, and only by moving creatively a lot of money around from places I didn't have it, we're able to survive. And then we had an inflection point, and then you kind of get better at doing it. But I think one of the greatest things is we have people like Sarah now to really guide us, and they're specialists in this space. And while there are many attorneys you can kind of turn to, I think there's just, kind of few that really kind of have entrenched themselves in this space and that really understand it. And they understand kind of not only the broader implications of, what starting your practice looks like in 2024, 2025, but also very specific kind of directives on what it's going to take to be, to be compliant, to help you get set up and hopefully to stay out of trouble. Because I think, this field of medicine, some people don't like to refer to it as industry, but this field, I think you're going to get more and more regulations kind of being imposed on it, because you are getting kind of this massive influx of both medical professionals, patients, private equity, businesses. Everyone's kind of jumping into it. So out of this chaos, I think ultimately over the next 3, 5 years, we should see kind of more regulations kind of coming in. And, going to kind of hand it off to you, Sarah. What do you think?
Yeah. Well, I'm Sara Shikhman. I'm the founder and managing partner of Lengea Law. And I've definitely been in the shoes of a med spa owner myself. I started a med spa with my ex from one room, a tiny little room in the middle of nowhere, Columbus, Ohio, a building that had, paint on the windows and looked like it was half abandoned, so much so that our Allergan rep said she called her manager the first time she came to our building and said, if I don't call you back in, 10 minutes after this meeting, please call the police because I don't know about this neighborhood at all.
This is
So
before law school, Sarah?
no,
Sorry to
no,
interrupt.
this is after.
Oh, after.
Yeah, I finished law school in 2006. I went to Penn Law for school, and after doing that, I became an entrepreneur first. And then I started this law firm only after having had the experience of being an entrepreneur and starting a couple of different businesses, including a med spa business. But yeah, that first one was, one room. And then that was in Ohio. And I had the wise idea to have a second location in New York. I wouldn't recommend that strategy now to anyone where you choose your first two locations to be, an 8-hour drive away. But that's how it started for me. And that was back in 2015. So I haven't been in this industry since 2008, but I've been doing this for a while, and now I'm super privileged to have lots of clients in this space, and wanted to talk about what are the hot legal topics that are coming up over and over now. And people have lots of questions for us all the time, and I'm so happy that we got a chance to do this Q&A and answer any questions. So I guess, Hardik, do you want to kick it off with some questions?
Yeah, and so, we have 22 participants. I have a list of questions I've actually already collected from some of our members. And so I'm going to kick it off. But for those of you that have joined us, please feel free to ask questions. This is an opportunity to really pick the mind of someone who's kind of giving us this valuable time to, really shed some insight into what some of the things we're involved in and what we're doing. So feel free to ask questions. But Sara, there's a recurring theme in kind of the types of questions that keep coming up, and they range everything from, and we can start with maybe the structure of med spa. Like, one of the common question is, what is an MSA, MSO type structure, and when would you really need it? What if you are already a medical professional, but let's say you're a nurse? How does the corporate practice of medicine fit into this? And, if you can kind of just shed some light on when we would need an MSA,
Yeah,
MSO structure.
definitely. So there are two types of states in the US. There are states that prohibit what's called the corporate practice of medicine, and there are states that don't. So in every state in the US, it's pretty simple to just open an LLC, right? You can go to LegalZoom, you can ask your accountant. There are lots of different ways. But to start a medical business in states that prohibit the corporate practice of medicine, you, assuming you're not a doctor, can't run that business out of a simple LLC in most of those states. And so what that means is if you're not a doctor, but you want to start a medical business in states that prohibit what's called the corporate practice of medicine, you have this legal workaround that you have to go through where you would start what's called a management company. And that company could be very powerful. It could have lots of assets and control and hold the lease and buy a lot of the equipment. And that would be your company owned by you, even if you're not a physician. And then your company, your MSO, which stands for Management Services Organization, would enter into a contract with a physician's company, or in some states with a nurse practitioner's company. And that contract would be called a management services agreement. So instead of a one company structure, it's a two company structure in these states that prohibit the corporate practice of medicine. That's the most common way that this is done.
And that is predominantly to take advantage of driving revenue to the management company, even though they are a non-medical entity.
Yeah,
Uh,
revenue and giving control to the management company of the business side of the things, even if they're not a doctor.
and can you comment on, like, how many roughly out of 50 states, how many states roughly have kind of the CPOM doctrine and how many don't have it?
Roughly 30. But what's interesting is a lot of the bigger by population states have it. So New York, New Jersey, Pennsylvania, Texas, California, all of those states prohibit the corporate practice of medicine. So in all of those states, you need some kind of MSO structure to be compliant in this way. Some states, though, are a little bit more kind of in the middle, where they allow physicians and non-physicians to be partners in a company, but the physician would still have to have a majority stake. So that kind of structure is possible in some states too. Like California, for example, a physician can own 51% and then a registered nurse can own 49. But that structure, if I'm representing the nurse, I would say that structure is not so great because then you're married to someone in essence, and they have a majority share, and maybe you're doing 99% of the work. And if you want to get divorced, you're going to have to buy them out.
Can't you, in scenarios like that, can't you um, basically describe or show what kind of shares they may be? So they may be, non-voting shares, or, in terms of distribution, you only get a certain amount as opposed to ownership.
Yeah, you could have different classes of shares, but in states that have a strict prohibition on the corporate practice of medicine, like California, for example, if you essentially make the physician have 51% but of the shares that are not, don't have any power, the boards may see that as a non-compliant structure anyway. So it would be hard to structure it that way, where essentially you could just say, okay, well, from now on, you don't vote, your shares are worthless. I'm buying you out for $5. See you later. They would see that as a non-compliant structure.
Yeah. Okay, cool. So we know when kind of, these MSO type agreements, and kind of segueing from agreements. One of the common question that keeps coming up, and there have been, kind of certain changes in the law and the FTC in terms of non-competes, which was, I believe, overturned. The ban on non-competes was overturned in federal court, right? So right now there's a stay on it. And most recently, there was a legal case, I think, a firm, Arnold and Porter,
Mm-hmm.
represented Sinosure, right? Because they lost, like a quarter or whatnot of their sales rep to another company, Reveal Lasers. And that was successfully litigated. And one of the things was non-compete and non-solicitation.
Mm-hmm.
So how does that, because I've heard both sides of the spectrum that non-competes don't really hold up, number one. Number two, but they can serve as a deterrent, because if I'm a medical professional that's working for a company and I've signed this non-compete, even if it doesn't hold up, I'm going to have to hire an attorney. And any attorney kind of worth anything is going to be at least $500 to $800 an hour. And this is something that could potentially drag out for some time in court. So can you comment on non-competes, non-solicitations? Where does the law in general, this applies to a company, a corporate structure, but how do you think that will translate to an individual?
Yeah, great question. And what's interesting is in the last, I would say 6 months, the pace of regulatory change has really amplified. Like in the last 6 months, first there was a non-compete ban, then the ban was overturned. There was an FDA decision to remove tirzepatide from the shortage list. Within 2 weeks, it was stayed. That has
Yeah.
never that pace that pace of change has never really happened before throughout my years of practicing law. So something is really definitely happening there.
Yeah. So, and what advice would you give? Because most of the people watching this are going to be, kind of the solo practitioners, or maybe they're getting their foot in the door, and it's becoming increasingly more difficult for some of these newer injectors to find a place to work, and they are being presented with these contracts. And I can see both sides of it, because again, in our Facebook group, we see the scenario all the time where an injector leaves you, opens down the street, and you've spent a year or 2 years training them, molding them, guiding them, and then they kind of take off. So how do you see, as it applies to a new injector, both, and can you comment on both sides of the equation? So I'm going to make it a little more challenging for you. If I'm a company and we're expanding, and some of the injectors we hire are new, we spend a phenomenal amount of time. They must train with me and the senior injectors for at least 2 months before they can even do the most basic of procedures, let alone the advanced procedures. And during this time, they're getting other training. We're getting some of the pharma companies to do the training. We're sending some of our injectors, across the pond to England to get more advanced training. We're really putting in tens of thousands of dollars into getting our injectors to be kind of top level. So how do you see something like that protecting us? And on the flip side, if you are a new injector looking to join a company that's going to really be, supporting your growth, what are your options?
Yeah, so great question. So I'll talk about the employer perspective first. My answer would actually be very much dependent on who I'm representing in that particular scenario, right? Because I could see both sides, and I've been the employer. And I've been the employer suing an employee for a breach of a non-compete. I've been the employer suing an employee for a breach of a non-compete where we spend 50 to $100,000 in outside counsel fees. And at the end, all the court did after months and months of fighting was say, okay, she can't do this for, let's say, 3 to 6 months. So I think that in the states that allow non-competes, if I represent the employer, I would say it is fair that if you're hiring someone brand new and you're giving them lots of training, it is fair that they sign some kind of non-compete. But it's not fair if they sign a non-compete that says they can't work within, I don't know, 25, 50 miles, because how can
Right.
you expect someone to travel so long to go to work? So I think you have to, in the states that allow non-competes, have something that's as narrow as possible to protect yourself.
Okay, so
Um,
it's something more reasonable. So maybe 25 miles is extreme, but maybe 10 miles
yeah, and
is
depends on
something where the
where.
courts may actually look a little bit more favorably on the employer in that scenario.
Yeah,
Uh,
like in Manhattan, 10 miles would be way too much. In
correct.
Manhattan, 10 blocks may be the right number,
Got it.
right? And then besides that, how you define competition and how you define solicitation in the contract really makes a difference. And always remembering from the employer side, sometimes I get contacted by people and they say, "What? This person's been working with me for a month and now I want her, decided we should have a contract." It's too late at that point to have somebody sign something most of the time. They're just not going to want to. So the time to get a non-compete and non-solicitation signed is when they start. And there are lots of other things you could put in there, like a mutual non-disparagement clause, um, a clause where they're not going to try to also solicit fellow employees to go work with them. So I do think that non-competes are necessary, especially in this industry where people are graduating from school and they don't know how to do this. So someone has to pay to teach them. That
Yeah,
person deserves to be reimbursed.
yeah, absolutely. And that's honestly, as we kind of expand, we put that in there that if they do leave before a certain amount of time, that there is a certain training cost. One would hope that whatever organization you work for ultimately creates a culture in place and a pathway for your future and success that people don't want to leave you, right? That is kind of the holy grail, that you really cultivate something. But again, you're going to get some entrepreneurs who are going to look. That's how I did it. I learned by working my first job for 6 months for someone else,
Hmm.
and I left. So I don't blame people for seeking their own path, but I think there has to be kind of a certain amount of standard or period of time where you have to pay back your dues at a very minimum. And at
Yeah,
that, you know,
yeah,
uh, and
definitely.
if you are representing the medical professional, what how would you fight this? And let's say it's a reasonable contract that you're in a state like Maryland and 10 miles, you know, which is reasonable as opposed to New York, where, as you mentioned, 10 blocks, or in Texas, maybe it's 50 miles. It's such a big state. So how would you kind of, because as far as we're concerned, the non-competes are still in effect.
Hmm.
I mean, correct?
Yeah,
So
in the states that allow them, they are. Yeah, so what I would tell an employee that I'm counseling on this is try to negotiate the time range, try to negotiate the geography of the non-compete, and also propose something else. Say, what if you pay me a lower salary during my training period? Or what if we agree that I have to meet some kind of performance standards after the first or second year? And then maybe you give me a retention bonus where it
hmm,
makes sense for me to stay. So if you're not offering me enough of a salary or a very strict non-compete and you want me to keep staying, okay, then how about we agree on some minimal goals that I'm going to work toward, and then I could get some sort of bonus. So I think thinking about it in that way, I would say that. The other thing is maybe put in a clause to say, okay, if the non-compete is breached, the amount if I'm representing the employee, I would say the maximum amount that I could be sued for is X. So right away, you're putting in some kind of clause that caps the amount that potentially you would get sued for. So you can do something like that as well. Um, I also I also ask people like, is this really what you want to do? Because what happens a lot of times is people change their mind. Like I'm sure you've experienced the most eager people, uh, somehow
Yeah,
due to situations, all of a sudden realize they don't want to be in aesthetics anymore.
it happens all the time. We've fortunately been blessed that, for the most part, we picked the right people. A lot of them, about half have been new, half were seasoned to begin with. And they're just someone that have a solid clinical background, because we're seeing a lot of these medical professionals just recently graduated without any clinical background. And remember, we are practicing medicine. So to at least, even if someone is new, but they've had clinical experience in the ER, one of my favorites is either ER or ICU nurses or nurse practitioners. I'm an ER physician by training, and they have saved my butt on more than one occasion. In general, they're very sharp, they're very smart, they're used to stressful scenarios, they're used to dealing with patients at their best and at their worst. So
Mm-hmm.
to me, that pool is particularly enticing, and I've had good luck with that. So I hear you, and I think we're going to finish this off. Someone asked, "What is a good cost for training costs?" Like if you are the medical professional, what's a reasonable amount? So what we put in our contracts is $20,000.
I think that's very reasonable.
Because I charge about 4 to 5 for about 6 hours worth of training. And when we get a new injector, I spend at least a full 2 months, 2 to 3 days a week, just one on one. That's all we're doing. We're training, we're talking, and then, I reach out to my pharma connections, get them additional training, because when we hire someone, we want them to keep our patients safe. We don't want them to do anything that's going to jeopardize. A lot of times, some of these newer injectors attend one training course and they're kind of injecting people. So I think 20,000 is what we do. We feel it's reasonable. And that's kind of where we're at.
Yeah, and my one suggestion there would be to make the training reimbursement type of contracts as enforceable as possible, and to also protect you in case of a board investigation. Document the training in a very specific way. So it would be like Amy's employment file shows that she had this
Great
500 hours
point.
of training. She practiced with 20 syringes of Voluma and
Yes.
20 patients with Jeuveau, and this is how many hours and time and all that stuff. The more documented, the better it's going to be for everyone.
We actually just put them as actual patients in our EMR, and we block it off. And there's, a complete kind of history on that. So, but that's a great point, because in law, if it's not documented, it didn't happen, or it
Yeah,
didn't happen the way you said it happened.
right. People's memories are very fickle,
Yeah,
unfortunately.
absolutely. So I'm going to kind of segue from kind of these types of questions to, back during the pandemic, when we were just opening, and I was asking my, medical professionals, practitioners to come back. Some of them didn't want to come back, and this is when there was that initial closure. Then there was a time frame where we could actually come back and open after 3 months. We closed in March. I think June was one of them. Someone actually filed a complaint that they felt unsafe to come back. Did you know that triggered an investigation on our behalf? We had to hire an attorney, and we had to show all the protocols and procedures that we were following according to the CDC and all those things. That still ended up costing $20,000. But as this field grows, I think what people don't realize is that having an attorney by their side becomes more and more important, not just when things go wrong, but hopefully to kind of have the procedures, the protocols, the audits in place that when someone does come in, when the state does come in, when a board comes in, they're going to be asking certain questions. What do you think each practice should have, kind of even before they open, or maybe shortly after opening, like a checklist of things they need to do? And what do you do to help them with that?
Yeah, I think a lot of times people may think that hiring an attorney will be something that's very expensive or very complicated, and it's
It
going to,
can be.
yeah, I think it can
It
be with
can
some
be,
people.
Sarah.
It can be with some people. I think it can be, but it doesn't have to be. Um, but any basic competent attorney who knows this industry will help you have a couple of basic things in your practice. So the first thing is written contracts with everyone around. So written contracts between your providers and your medical director, um, written contracts between you and your patients, which is your consents, not on paper, but in an electronic medical record, written protocols for what is done in your practice and how it's done. So for example, the protocol would say at our practice, these are the 10 areas we do Botox, and this is the maximum number of units we put in each of these areas. And then your staff would sign off on these protocols and your medical director too. And that would protect you in case somebody ever goes off the protocol and they are doing something, in a rogue kind of way. So at the very minimum, you would have that. At the very minimum, you would have your insurance policies in place and have them reviewed by an attorney to make sure that a lot of times you may fill out an application when you first start your business and you say, I'm going to do microneedling, Botox fillers, HRT. You forget that a year later you started to do chemical peels and lasers, and you don't add that to your policy. You don't have it reviewed by anyone, and then your insurance doesn't cover it. So at the very, very, very basic level, I would have that. And then clear documents about who owns the practice and who's the medical director of the practice. So in those states that prohibit the corporate practice of medicine, you would have your MSO and MSA documents right in the office.
Mm.
But related to this, I would say this, and this is very important. If you have a visit from a board, announced, unannounced, whether it's a call, an email, or in person, do not engage with the investigator on your own. Get a lawyer right away. Say, I'm represented by a lawyer. I'll be in touch with you with their information soon. Even if you're not represented by a lawyer at that very second, find a lawyer and have them communicate for you. Do
What if
not,
they show up? Can you say right
absolutely,
now, I'm not giving you permission
absolutely.
to go through my premises. You will need to contact my attorney
Yes,
and I will have
absolutely.
them reach out to you. So,
Yes. If they show up for any reason, unless they have a documented complaint about something specific in a back room like cleanliness. If they just have a complaint about GFVs are not being performed or whatever, some improper
right.
procedure, you could tell them we're represented by counsel. I'm happy to show you whatever you need, but you're just gonna have to coordinate through them.
Okay, fantastic. And since you did bring up consent forms, one of the questions I've encountered is how often do you get consent forms? Do you do it once a year? We tend to do for injectables every time they come in, but if someone comes in for laser hair removal, they're coming in month after month and they may be coming 6 to 10 times. Do you do it every month, every 6 months, once a year? Like, is there a legal precedent that requires a certain standard to be met? Or is it every time you do a procedure, you got to present it? And is a written contract enough? Or do you also have to document a verbal kind of discussion?
Great question. So first thing is there isn't a law that says consents have to be done X number of times or this often in X state that I'm aware of. However, in this situation, there's a standard called the reasonable doctor standard. So if somebody was getting sued for malpractice and there was an expert witness representing the other side, could they find an expert witness to say, hey, they should have been doing consents every single time? That's the standard of care. They probably can. And because of that, you could make the argument that probably a reasonable person could say that you need consents every single time. So because of that, I think the best practice would be every single time a patient is seen and they're about to do a procedure, have them sign a consent, whether it's a neuromodulator, laser, whatever. Because also what happens is that gets rid of the situation where the patient can say, well, between the time I signed a consent and the week I got the treatment, I got this new thing, but no one asked me about it. And so I didn't tell anybody. And there was nothing, I wasn't reminded that I shouldn't go in the sun or whatever. Whereas if they're just signed a fresh consent that day that says, I didn't go in the sun, it's very hard for them to argue that, they didn't know.
And what are your responsibilities? I mean, I imagine a written contract, especially in an EMR, is a pretty powerful piece of document. But what if a patient does say, well, you know what, I didn't read all of it, or, this wasn't really explained to me, or I felt rushed, and they just put it in front of me because in a busy practice,
Mhm.
it's not that uncommon from some of our members to say, oh, here's a contract, just sign it, and, they go and do it. So what happens in that scenario?
I think that making the argument that I didn't read something, although I signed it, is a very difficult thing. So yes, of course, anyone can say anything. They can say they pressured me, I didn't read it, I didn't understand it, but your consent should have language in it saying where the patient specifically acknowledges that they read it and they understand it. So it's not a defense that to say, oh, I signed this consent and I didn't read it, or I signed this non-compete and I didn't read it. Well, the obligation is on you to read, and the presumption is a reasonable person would read something before signing. So if you didn't read it, that's more your fault than the practices.
Hmm, okay. You know, we are seeing that in cases where a medical director is required, and sometimes it could be a physician, sometimes it could be a nurse practitioner. And a lot of these medical directors are for hire for as low as $500 a month, $1,000 a month. Now, kudos, as a side gig, I personally don't see myself handing out my license for $500 a month. But I suppose if you have like 20 people underneath you, and I'm sure there's restrictions on how many you could be a medical director for, depending on the state you're at. How much liability extends to a medical director? What is the difference between a medical director, who is a physician, and a collaborating physician? Is the liability similar? You know,
Great question. That really depends on what the contracts say. You could have a contract that makes a medical collaborator have as much or more liability than a medical director contractually. So it depends on what the medical director agrees to in the medical director contract or in the states that prohibit CPOM, the management services agreement. So those contracts have to be really heavily read and negotiated. There are all these medical director companies now where they work with many medical directors and they have their contract and they present it to you and they say, okay, sign it. This is our form. It's all good. The problem is with those contracts is they're very heavily favored. If you're not the medical director, they're very heavily favored toward that company medical director. So you yourself are basically saying you're taking on full responsibility, even though you're paying some money to this medical director. So it's all contractual at that point.
so that contractual agreement would supersede a board's regulation. I mean, the medical board, and I mean, they operate in their own realm. You don't
Yes,
need
but they
justification or the law per se to get in trouble with them. It's
Yes, that's true, but they often don't have strict regulations. Like they don't say, hey, medical director in X state needs to review 10% of charts and do one office visit a month. Most states don't have regulations like that. Some do, but most don't. So it's up to the contracts between the medical director and the practice to see who's going to be responsible for what. And if bad things happen, if there's a lawsuit, who's gonna indemnify the other person? Meaning, let's say the practice gets sued and you're the medical director, you probably don't want to be in that lawsuit, but if there's nothing in the contract protecting you, then you're going to get sued too, and you're going to have to figure it out with your insurance company. So you have to, like, when doing medical director stuff, think about, okay, let's say you're the medical director, you're getting paid $1,000 a month, but one license investigation in one state usually triggers investigations in many other states because they all talk to each other. They have a requirement that says, you as a licensed professional here have to notify us if you're under investigation in any other state that you're licensed in. Many states have this requirement, so you want to make sure that you're not violating that.
Okay. Sarah, it looks like all of a sudden people are asking lots of questions. If you can see them, I'm going to let you pick which one you would like to answer.
Yeah.
But we have a lot of questions. One of them's interesting. Like, are you able to discuss any specific cases where, someone did get in trouble, whether it was a medical director, whether it was a nurse practitioner for, maybe doing something that was blatantly wrong versus something that wasn't kind of, that, oh, I didn't know I could get in trouble for that.
Yeah. I could discuss something. So, um, for example, um, two different cases. One is a big practice was ordering stuff from a manufacturer and then reselling that stuff to a bunch of other practices.
I'm going to stop you right there just for a second. On our Facebook group, we have 28,000 members, Sarah. And I work every day to remove these posts where people are trying to sell things like neuromodulators because we've actually received warnings from Facebook like, you can't do this, so this is like legitimate. Like, you can't buy these things from anyone other than the manufacturer in pretty much 99% of the cases.
Yeah. So in this case, yeah, they were buying the product from the manufacturer and then they were reselling it to their friends and other practices and whoever. And they got into a lot of trouble and had to restructure operations, pay some fines. So that was a really unpleasant situation. There was another practice where they answered an ad that they saw via email that said, we have authentic Juvederm filler for $100 a syringe or something like that. And then they bought a bunch and they didn't ask any questions. They didn't say like, where's it come from? They said, oh, maybe we could play dumb in this case and just order this. And then the DA came and they suspended everybody's license. And they tried to have lots of fines and put the like head medical director in jail for illegal importing. So I've seen that. I had a situation where a client was had a very busy practice, but all that was done is there was basically a registered nurse, and that person was the one doing everything, including like issuing the orders, doing the good faith exams, just running the practice. And this person was very experienced and very knowledgeable. However, that isn't enough, right? That couldn't have been done in that way. And so that person's license got suspended for I think a year, which is a long time for someone whose profession depends on being licensed.
Yeah, that's not fun. So, I think people kind of assume that, they're going to kind of profess ignorance, but in the eyes of the law, ignorance typically, number one, doesn't protect you. And to be honest, most people know, when they're doing something wrong, it's probably not legitimate. Like, so I think everyone just has to be a little bit more careful. I think we are going to answer two more questions, Sarah, and I'm going to let you pick the next one as well, and I'm going to pick the last one.
Okay, sure. I'll answer two, well, I'll answer one in a combined way. So, a person asked, how do I become a KOL, a key opinion leader for brands like Merz, Galderma, Allergan? I happen to know that area quite well because I've helped quite a few people become KOLs. The number one way is volume. The more you order from these companies, right? The bigger your account is, the more they see you as someone who they want to talk to other people. Because at the end of the day, what they're looking for is people who are going to influence other people and help other people become big customers of their company. So the number one way to become a KOL is to build a quite a large practice and then literally go to your rep and say, hey, I know you can nominate a person every year from your territory to your manager. So this year I'd want that person to be me. That's the way to do it. And then another question here was um NP laws in New York and opening your own practice in New York. So New York is one of these states that has independent practice authority for nurse practitioners. And so
With 3,600 hours, right? I think that's the
with
criteria.
3,600 hours of practice as an NP, exactly. And then once that's done, an NP can form their own PC or PLLC, which is a special legal structure in New York, and among other things, then can become their own medical director of a practice. There are a couple of other things you should have in place, like the protocols that I mentioned, the insurance in place, depending on if you're going to do cosmetology procedures or have cosmetologists, you may need a license from that board. But essentially, those would be your first steps for New York. So those are my, do you want to pick one?
Yeah, I will pick kind of the last question, and I'll pick two because this kind of asked right now. Just to kind of recap, we can still compound tirzepatide. There has been kind of a stay, or I don't know if it's been a reversal, but a stay on the decision of the FDA to limit compounding because some of the pharmacies that stopped like overnight allowing for this now all of a sudden you can order from them again. So I imagine at least for the time being, practices are able to order from 503B registered pharmacies for that compounded tirzepatide need. And even when this decision came down, I believe there was a period of 2 months that they were giving to the pharmacy. So the inference would be that if you were a practice, you probably would have been okay if you had just kind of distributed the supplies over the 2 months that they give to the pharmacy or sometime thereabout. So can you just kind of comment on that real
Yeah.
quick?
Yeah, definitely. So yes, so what happened was the FDA removed tirzepatide off of its shortage list, which meant that it could no longer be compounded. And then a bunch of compounding pharmacies said, okay, we're not compounding this anymore. But the FDA does usually give a 60-day period for people to come into compliance. What it doesn't like is if during that 60-day period you end up ordering for 200 new patients a year's worth of supply of tirzepatide. I think that still the FDA would not like that. And what's even what's even a bigger issue is Eli Lilly would not like that. So Eli Lilly, what they would try to do is they would subpoena the records of your compounding pharmacy. Somehow or another, they would get that subpoena granted. And then they would find out that you place these orders, and then they would say, okay, well, why did you do that? Did you really legitimately have these patients in an emergency in this 60-day period? So I think it under the old rule where the FDA was saying it's off the shortage list, even the 60-day approach is a little bit legally risky. But then the FDA all of a sudden said, never mind. We're revisiting this whole situation. We're putting everything on hold. So for now, tirzepatide is still on the list. We're reevaluating what to do. And it seems like they're going to issue some kind of decision, but with what's happening with the election and everything, I feel like they're probably not going to do anything until the election happens. But The
I
pressure
can't
on it is
imagine they
very
would
strong.
reverse it again, right? Like, because you said this is unusual.
This is extremely unusual. Like when I saw the news, it was like a Friday night at, I don't know, 5 p.m. that it came out. I could not believe that this happened. It has never in my practice, and I've been doing this for, I mentioned I graduated law school in 2006, so I've been around for a while. I had never seen anything like that.
Yeah. And I think we'll kind of finish this one. I don't know if you know that is legit script certification necessary for GLP-1 clinics doing telemedicine. I imagine only if they're you would need the legit script because we've tried to get the legit script if you are marketing it, right? Like it's digital marketing like Google or Google Ads or
Yeah,
Facebook, you can kind of get around a little bit still, but in terms of Google Ads, you do require that legit script more for marketing, but not necessarily if you're just doing telemedicine, as long as, I don't know. I'm just
yes,
guessing.
and we've helped a few people get legit script certified in different states. So it is doable to do. Um, they require things like insurance and your state registration, and they have a bunch of forms to submit that we could help you with. So it is doable, but it isn't like a legal requirement from the state. It's more like a marketing requirement from some of the companies where you may be running ads.
Okay. I think, Sarah, we're going to stop here and just maybe you can talk about, I think people know what some of the services you offer, and you're kind of on the aesthetic nexus as well. We do these webinars. This was really awesome. I mean, we had a lot of people asking. It would be great to be able to do something like this, but how can people get a hold of you and what are some of the services you offer? And you said lawyers don't have to be expensive. Well, you've been doing this a while. Are you saying you're not expensive?
I think I'm worth it. So
Ah, okay.
I don't think I'm the most expensive in the market. I think we're probably not the cheapest either. Uh, we believe in very transparent pricing. So all of the pricing for the firm is on the website. Our website is lengealaw.com. And there you could see exactly how much we charge. So our current price for our most popular package is about 6,400. And that is usually enough to either take a practice from being non-compliant to being compliant, or set up a new practice from scratch, or help someone with some kind of big custom project. We work with practices of all sizes, like from one room to 50 locations. Um, and I think what makes us different is I actually started and ran a med spa, so I know what it's like when people call me and they are facing a problem. I've been there, so I can really relate. And um, we're also part of the Aesthetic Nexus, and with that, you get a free consultation with us. So if you book through there, make sure to mention that that's where you came from. Um, but yeah, we have a team of 12, and yeah, I'm working all the time these days because this field is ever evolving.
And Sarah, what states does your law firm cover? Is it all 50 or you have partners in kind of respective states? So let's say someone from Alaska reaches out to you. Um, you
Yeah,
have lawyers that are licensed in all 50 or you have partners that you work with?
for our in-house team, we are licensed in about 20 states between all of us. And then if we need to have somebody as a local counsel, we have a list of local counsel in every state that we work with. But in terms of our internal licenses, we are licensed in a lot of the biggest states like New York, California, Florida, Ohio, Texas, Illinois, whatever, whatever.
Yeah, exactly. All right. Well, I really want to thank you for taking the time. I was just commenting before this started, you're like everywhere. And you're really kind of entrenched in this industry. So, I highly recommend that. We're pretty honored to have her as part of the Nexus. She's always available. She gives a lot of advice for free, as you can see that she did today. And so, if you need anything, visit lengealaw.com. And you can also go through the Nexus. She does have a booth there. So thank you again, Sarah, for taking the time tonight. I'd love to be able to do one of this in the upcoming future, maybe in a month or month and a half. I think this was great. And thank you everyone for joining us. On Facebook, you can type in all of your questions as you need, and she's in there somewhere. So when she does have time, she does respond, which is pretty much almost all the time. So thank you again.
Thank you. Thank you, Hardik. My pleasure. Bye.
All right, guys, have a great night. Thank you.